Hello, everyone, and welcome to the third episode of TCLF One-On-One. Through the One-on-One series, we aim to interact with the best legal professionals from India and around the world. We are honored to have Mr. Mohit Khubchandani as our guest for the third episode. Mohit, sir, is an incoming ICJ Judicial Fellow. He is currently working as a research assistant at the International Law Commission, United Nations. Previously, he has also served as a legal consultant and advisor to multiple United Nations agencies as well as coveted Indian departments such as the Permanent Mission of India to the United Nations. Additionally, he holds a master's degree in international environment law from Stanford Law School. Sir, it's an honor to have you. Could you please tell us more about yourself?
Thank you very much, Shashwat, for those very kind words. It is indeed an honor to be here. And I must say that the Contemporary Law Forum is rising towards success exponentially. So thank you very much, and kudos to you for the great work that you've been doing. Thank you very much to everyone who is listening to this session. And I hope that you and your loved ones are doing great, doing healthy and uplifted during these times. I am not sure as to how I can elaborate more after the detailed introduction that Shashwat has given, only to the extent one thing that I'd like to say is that the constant endeavor in my entire professional career of exactly 5 years thus far has been to try and experience public international law, international arbitration, and a cohesion of these two with international environmental law in the widest lenses as are possible within this sphere. So I have tried to be a litigator, tried to be in academia by being a teaching assistant, tried to be in public policy, and now I'm extremely thrilled and honored to be waiting for an opportunity to see it from the adjudicatory standpoint. Thank you.
Uh, you're an inspiration for all international law enthusiasts in India, sir. I'm sure that whoever is listening to this would be inspired by your journey. So every law student studies international law as a compulsory subject in law school. What was your first encounter with international law? Let's just call it the moment wherein you decided that I have to study this subject more. This interests me.
Actually, thank you so much for asking this question, and nobody's ever asked me this, not even my friends. So probably if they are listening, they'd be delighted to know this. So often people join law school and develop interests in one or few areas of law. Whereas in my case, I have no hesitation to say that the reason to join law was because of my fragmented fascination and understanding of international law. So let me in fact give you a very small instance which will elaborate about my first introduction to this. So my grandfather was a criminal lawyer in undivided India, a place
Okay.
called Sindh, which is right now in Pakistan.
Right, sir.
In fact, at the time, he was a colleague to Mr. Ram Malani, who needs no introduction.
Right, sir.
So when he migrated to India, owing to several circumstances in which I wouldn't get into, he couldn't really set up a practice, and thereafter my father also couldn't join the profession. So my grandfather had the habit of reading out the newspaper to me to increase my general knowledge and to refine my English. And I was about 5 or 6 year old then. So I used to ask him about his experiences as well and generally about law. So once he told me in the very simplest words that law is so beautiful that there's actually a world court that does world justice. And of course, at that impressionable age, I didn't instantly have an understanding of that concept. And he even passed away in the year 98 when I was only 6 years old. But then coincidentally, the very next year, in 1999, the Atlantic Downing case, which was decided by the ICJ, India versus Pakistan, was all over the news. and the then Attorney General for India, Mr. Soli Sarabji, had successfully defended India, and I read a bit about it. Of course, after that, there was a huge disconnect because every student gets involved in their regular studies. But then again, in class 8th or ninth was when I was actually introduced back to law, and there was a mooting society in my high school itself.
All right.
And that was when I actually read about the ICJ particularly, and as a result international law. So when I entered law school in 2010, the very first thing that I did was to go to the library, go to the very first section of international law, and the very first book that I picked up was Ian Brownlee, and the very first section that I saw in that book was sources of international law. So that, in a sense, has been my driving force to join law, in fact.
That's amazing to hear, sir. And in fact, it can be said that your love for international law traces back to school life and not just law school life. So it's fascinating to hear. So we have seen that in the recent years, India's engagement with the International Court of Justice has increased than it was in the past. In fact, some of the cases have garnered international attention. Nations are hooked as to what will happen in that particular case. What are your views on that?
So I think this is a great transition from the Atlantic Downing incident that I mentioned to you in the previous question. So if we look at even the timeline, since 1999 till 2016, India was not a part of any litigation before the International Court of Justice. However, in only a span of 4 years since 2016, India has been involved in 3 monumental cases before the International Court of Justice, and has been fortunate to be on the winning side in all those 3 cases.
Right.
And I must share with you that I have had the great fortune of being involved in all these 3 cases in one way or
Okay,
the
sir.
other.
Okay.
So I can perhaps elaborate about these 3 cases in accordance with their timeline.
Right, sir.
Now, first case was in 2016 when the Marshall Islands took India along with other nuclear nations before the ICJ, demanding that they prohibit themselves from conducting nuclear tests within
Right,
or
sir.
near their territory. Now, that case was dismissed on the very ground that they lacked the mootness, and the
Right.
case was unripe to be decided before the court, a notion that we call lack of existence of a dispute in public
Okay.
international law. The next case, which was in 2017, and I think whether or not someone is passionate about international law, that person must have heard about this case, which is the celebrated Kulbhushan Jadhav case.
Right, sir. Right.
Now in this case, even though provisional measures were given in 2017, this was finally decided in 2019, wherein the International Court of Justice ultimately held that consular access had not been given to Commander Jadhav, an Indian national, in accordance with Article 36 of the Vienna Convention on
All right.
Consular Relations 1963, to which both states were a party to. And the court made an unequivocal statement that Commander Jadhav not be executed in Pakistan till such remedies are exercised.
All right.
So the third case was in February 2019, and this, unlike the other 2 cases which involved the contentious jurisdiction of the court, involved an advisory opinion concerning the Chagos archipelagos in Mauritius.
Okay.
Now, the United Kingdom asserted their sovereignty over this Chagos archipelago, but Mauritius contended that in accordance with their past treaties and their bilateral customs,
Right.
the sovereignty now belonged to Mauritius, and India, being a key friend and an aid to Mauritius, actually submitted a memorial before the ICJ and espoused the cause of Mauritius, and ultimately the ICJ held that decolonization shall happen in that area
All right.
concerned.
So these were holistically the cases that India has been involved in as far as the International Court of Justice is concerned. So interestingly, ever since the start of this pandemic, newspapers, blogs have been flooded with articles talking about fixing the liability upon China for the spread of this pandemic. Now, the merits of these claims are something that we do not want to delve into, considering their voluminous nature. But I want to talk about a very specific issue, that is the jurisdictional issue. So, what is the entire issue regarding the jurisdiction of ICJ uh, in the entire fiasco that is happening?
Right. Thank you so much for this question. And this issue has, in fact, been the talk of the town. As a matter of fact, I myself have written a blog about the
All
advisory
right, sir.
jurisdiction of the ICJ with regards to the specific act of reopening of the wet bat markets
All
by
right.
China. So, before I delve in further, let me just, for my audience, try to elaborate on the two kinds of jurisdiction that the ICJ possesses.
Right.
Now, these jurisdictions are first the contentious jurisdiction, which is as per an understanding of Article 36, read with Article 40 of the statute of the ICJ,
Right.
as per which, if a case is adjudicated between two parties, then it is binding inter se those two parties according to Article 59 of the statute of the court. However, for this jurisdiction to lie, there are two ways in which it can be maintainable. The first way is if countries have submitted instruments of compulsory jurisdiction before the ICJ. And the second way is if there is a multilateral convention which has a disputes resolution clause that references the ICJ, then countries, whether or not they have submitted that instrument of compulsory jurisdiction, can be taken before the ICJ.
Right.
Now, the second kind of jurisdiction is, of course, the advisory jurisdiction, which is in accordance with Article 65 of the Statute of the Court. And international organizations, specifically the United Nations Security Council,
Right,
under
sir.
Chapter 7 of the UN Charter, as
Right.
well as the United Nations General Assembly, have the power to refer a dispute that concerns international peace and security before the
Right, sir.
ICJ. Now, with this backdrop, let us consider the following fact pattern concerning a possible liability of China considering the outbreak of COVID 19.
Right.
Now, the first thing that I believe everybody must understand about the dispute is a very big caveat. Now, that caveat is nothing but innocent until proven guilty.
Right, sir.
So, all such discussions about China's liability under the World Health Organization's regime or the International Health Regulations of 2005 are unripe in the absentia of evidence, at least insofar as we speak right now. So, for
Right.
the purposes of accuracy, I will address your question by hypothesizing this entire question and
Right.
calling it the liability of country X.
Okay.
So now, in order to exercise these two jurisdictions, the issue of merits is actually not divested, which is
Okay.
why I mentioned that I will have to hypothesize the liabilities in order to establish at least the contentious jurisdiction.
Okay.
So let us consider several aspects of the international health regulations and the WHO regime. So without going into the specificities, countries are duty bound to share timely epidemiological reports to the WHO so that it can constantly monitor the outbreak of a disease and accordingly categorize it as an epidemic or a pandemic, as the cases might be.
All right.
In the current scenario, there has been a lot of debate about whether country X or several other countries have been timely in providing sufficient information to the WHO.
All right.
Now, all of this can actually only be established with the help of what we call fact-finding commissions or fact-finding missions, which are commissioned by the United Nations.
All right.
This, in fact, played a key role in the recent judgment of the ICJ in the case between the Gambia and Myanmar, when the ICJ held that Myanmar ought to give more protection to the Rohingyas. The ICJ placed considerable reliance on the report of this fact-finding mission. So, in this pursuit, actually, as recently as on May 18th, the World Health Assembly took a draft resolution for consideration. Now, this draft resolution was co-sponsored by 62 countries, including India, and in operational paragraph 9.6 of this resolution, the countries are calling for an investigation into the origin and zoonotic nature of the virus.
Okay.
Now, let us for a moment assume that as per the conclusion of this fact-finding mission, country X is responsible for its actions or inactions or delayed actions, as the case may be. It is only then that the entire mechanism under the WHO regime will get activated. It is only then that state responsibility can be imputed upon country X, and it is only then that other principles of customary international law, such as due diligence, negligence, can come into being for the contentious jurisdiction to be exercised.
Okay.
This is to the exception of just one principle, which was actually a talking point of my article that I spoke about. Now, this exception is the duty to prevent transboundary harm. And this was propounded in the Rio Declaration, Principle 21. And it says that lack of scientific evidence shall not be enough to preclude any action or inaction. In a sense, that any country which at this point of time has reopened its wet bat markets should immediately stop that practice, even if it cannot be conclusively proved that these wet markets are actually the real cause behind the outbreak of the virus. Because there is a substantial belief by scientists that this could be the case. And in such circumstances, I think currently, if something had to be instituted, it would be the advisory jurisdiction of the court.
So basically, it can be called as far as wet markets are concerned, a preemptory action from international law within the law itself.
Absolutely.
Right.
And
So,
if we are to look at other frameworks which can be of assistance to us, then the foremost institution that comes to mind is the United Nations Security Council. Because ultimately, if a resolution is passed by the United Nations Security Council, it is binding in nature as opposed to resolutions by any other international organization. Now, it is interesting to note that in 2014, in fact, after the Ebola crisis, even though there were about only 400 casualties, even though every single life matters a lot, yet the Security Council was very proactive in passing such a resolution. Now, the difference between that situation and the current situation is the exercise of veto by one permanent member in the pretext of saying that they would encourage votes by writing and not have votes in a virtual meeting, as a result of which any possible resolution pertaining to COVID-19 has not been able to be adopted by the Security Council. There are other means also whereby which we can have some redressal. Article 56 of the International Health Regulations gives an avenue for arbitration before the Permanent Court of Arbitration, which is, of course, consensual in nature, and countries may or may not agree to that. I have already spoken about the power of the World Health Assembly to take up this issue and try to resolve these amicably. Now,
Right.
in accordance with Article 75 of the WHO Constitution, if issues are not amicably resolved before the World Health Assembly, then they can be taken to the ICJ, and I have already elaborated on that jurisdiction.
All right, sir. You've told us the various options that are available to, actually present a case against China. Moving on from that, so do you think that the international law framework in its existing form is it sufficient to deal with a pandemic like COVID-19?
So I think your question has two prongs. The
Yes, sir.
first prong is about structural deficiencies, and the second prong is about institutional efficacies.
Right.
But before I go into these two prongs, I would like to make a general remark. And I would like to say that whether it is speaking about international frameworks or about international institutions, it is not legal scholars like us, but it is the political will and the onus upon member states to make them as powerful or as hollow as they wish them to be. So, with this remark, I'll first address the prong of structural deficiencies. Now, in the current context, the classic example that comes to mind, and I have perhaps already touched upon this, is the structural deficiency of the United Nations Security Council. The much abused veto power, and much has been criticized about that power. As I told you that a resolution was blocked by China by virtue of asking votes by writing. Now, the foremost change, then I think, which is required in the United Nations Security Council is A, at the very least, not allow the usage of veto when it concerns that particular nation itself. In the sense that not allowing nations to be a judge in their own cause when the veto power is concerned. And B, that when the United Nations Security Council was formed in the 20th century, the world powers and the entire world demography was different. Now, in this century, there have been a lot of emerging powers which merit a place in the permanent members. And the permanent membership of the Security Council must increase. And this is, in fact, a narrative that India has also been pitching since many years now. Now, in the context of institutional efficacies, another example that comes to mind, also from the current specific context, is the questions being posed upon the World Health Organization and also
Right.
upon the Director General, Dr. Tedros, about his alleged complicity with China. Now, whether or not the WHO has been wrong in dealing with the pandemic, but I honestly believe that this is not the key question to address. The key question is much more deep rooted. The key question is that whether international institutions can actually exercise autonomy in the current world order. And the answer is a plain simple no. That is because countries are able to have as much of a say in these institutions, which is proportionate to the amount of funding that they do to these institutions. So in this sense, most international organizations, not just the WHO, perhaps this is something that is being highlighted now, but most international organizations are structured in a manner which is more beneficial to the larger funders. The only way out, if we are to have institutional efficacy, is by way of sharing the burden of funding. Now, if today United States President Donald Trump has made an unequivocal declaration that he might withdraw his WHO funding, then it should be incumbent upon countries of the European Union, countries in Oceania specifically, to step up and contribute to this funding. There should be a metric to have caps of funding on countries in order to have an equitable say in these world institutions, and then these same frameworks will look more adept and effective to us.
Right, sir. On that note, sir, do you think there is a need to develop a global pandemic framework convention? Let's say by 2030, all nations get together and they draft a framework convention for this.
You have put me in a spot, Shashwat, but while I'm not entirely sure about the answer, but I have a food for thought for both propositions. So let us begin with the negative one so that we end with the positive note. Let us assume that my answer is no. And that would be because of the following reason. That would be because of the very nature of international conventions. Now, international conventions work on the basis of voluntary participation by member states of the UN. Many conventions, as we know, have seen a very lukewarm response from nations. Let us assume that there's a convention that has only 20 members. Then can we really say that the convention drives that particular notion of international law and is the determining aspect of international law? Probably not. So let us focus on one very imperative aspect, a power that lies with the WHO, which is the power to declare a pandemic in itself. Let us assume that this power vested not with the WHO, but under the realm of that pandemic convention that we are discussing, and the secretariat of that convention had the power to declare a pandemic. Now, with a limited number of membership, that pandemic would only apply to those member states of the convention, and the rest of the world would work in a fashion as it would please, as opposed to right now, wherein we may have our shares of criticism about the WHO, but at least on paper, the pandemic applies to the entire humankind, to all countries, whether or not they are a part of the United Nations. So we have to tread very carefully when we think about having a pandemic convention. Now let's assume that my answer is yes, that there should indeed be a pandemic convention. And the reasons behind that would be that if the convention comprises of standardized guidelines on testing, on operation of flights, on social distancing, on investigations, on quarantine regulations, on lockdowns and systematic reopening of lockdowns, then perhaps the current ad hoc system, so to speak, which has been adopted by countries as they please, could be dispensed with. Now, for example, the flights which were running from Wuhan much after there was an outbreak, whether or not categorized as a pandemic, could have perhaps led to a wider spread of the virus. Now, Perhaps if there was a convention dealing with the operation of flights in the event that a pandemic has been declared, then essentially all countries which are parties to that pandemic convention should have had to stop flights, and maybe we all would have overcome from this pandemic already.
Right, sir.
So ultimately, whether the answer is a yes or no will squarely depend upon the support that this pandemic convention receives from countries. Let's say if more than half of the UN members endorse such a convention, it is only then that this, by the help of political will, can become a comprehensive document that can govern this world and save this world from this pandemic, and God forbid if there is any other pandemic that is to follow.
Lastly, sir, what is your advice to international law enthusiasts in the present time?
So, this is a question that I am asked informally also many times. And I must say that we should look at this as an opportunity, which is a glass half full. Some people ask me about the fact that there are no internships on offer right now. They cannot go to universities to take part in co-curricular activities or the like. Now, firstly, I think everybody needs to breathe. This is because at the end of the day, this is a wonderful and rare opportunity to spend time with your family as well. And I know I might be digressing from international law, but I can tell you that I myself have never spent so much time with my family, and I'm cherishing this time. And I say so because if a few years down the line you are in an interview and you're telling an employer that in the lockdown I couldn't do much but spend quality time with my family, they will completely understand that.
Right.
They will not grill you about your inactivity during this period of lockdown. Now, this is more on a moralistic aspect, but more constructively, I think if you really wish to do something, adversities create a lot of opportunities. And I am pleasantly surprised these days with some messages that I have been receiving from some enthusiasts who want to simply research on propositions that I might have to give to them, whether or not they might fetch anything constructive out of doing that proposition. Because ultimately, I don't think that I am anybody who should be assigning work to someone, because I'm myself very young and struggling in such a career. Now, additionally, I think it's a great opportunity, as everybody is aware, to attend so many free webinars. It is such a wealth of knowledge by reputed people, and this is only happening right now, which is otherwise charged for. For instance, I am currently watching Professor Gary Bond's lectures on international
Right.
arbitration. One could even start something like the Contemporary Law Forum or have a
Right, sir.
podcast and invite people and have such simulating discussions. I think to sum up, I would like to conclude from a quote of the Bollywood movie Three Idiots that has stuck with me for my life, which is that just strive for learning and for immeasurable excellence. Success will definitely follow in due course. Thank you.
That's inspirational to hear, sir. And I'm sure that every law student, every young practitioner who's trying to make a mark would be inspired from this talk. It was 35, 40 minutes of absolute learning, personally for me as well as for the whole TCLF team. We are honored to have hosted you, sir. Thank you for gracing us with the opportunity. And uh, if you want to say anything to conclude, I would be very happy, sir.
It has been my absolute honor and privilege to be a part of this meaningful discussion. And thank you so much for providing me this platform. And it has enabled me to convey many of the queries that I otherwise receive in
Right.
the widest possible manner. So, all my gratitude to your entire team, and all my gratitude to everybody who is listening to this. And I hope that you stay safe and stay healthy and spend as much time as you can with your family. These are really moments to cherish. Thank you.